It's really a pleasure to be here. Quick quiz. This will be a cultural test for the audience. How many of you, show of hands will be fine. How many of you recognized the no-brainer, whose brain was displayed on the no-brainer slide that Paul put up? Okay, who? Keith? Homer. Very good. Homer Simpson. And that's probably very apt. A very apt illustration for a lot of the problems that we're going to be hearing about today. I had heard from Marcus Meyer, who runs our healthcare shop, about what a terrific program this is. He's been here the last couple of years, and that's part of the reason that I was very happy to accept this invitation when Marcus suggested that I might do it this year. Needless to say, you folks are confronting incredibly important and timely issues. We are too, maybe not necessarily from as different a perspective as you might think. And for us to have an opportunity both today and subsequently to interact constructively with folks like you, I think is mutually beneficial, and I want to encourage that going forward. What I'm going to try to do today is actually I'm going to start by giving you a little bit of an overview, a very brief overview of the Bureau of Competition and how we approach these issues. And then I'm going to drill down a bit into clinical integration, ACOs, and some recent legislative developments that have captured our attention. Some of you may, let me back up for a second. The Bureau of Competition consists, over which I have the privilege to preside for now, and for the past 2 years, and it's been a great honor and a great privilege. We have about 200 antitrust lawyers, and I know for those of you who have ever been on the receiving end of one of our investigations, you may actually think that all 200 are focused on you. I can assure you that's not the case. But it is the case that healthcare, broadly speaking, is one of our probably our highest priority in terms of the resources that we devote to it. And I emphasize healthcare, broadly speaking, because that goes way beyond issues that are teed up by physicians or other healthcare providers. But we do have, and our chairman has made it very clear that healthcare is one of his highest priorities. And when you think about it, it makes good sense, because we don't have unlimited resources. And what we try to do in terms of promoting competition for the benefit of consumers is to deliver the most benefit to the largest number of people with our policies and with our enforcement actions. And healthcare services and products are consumed by everybody. And so to the extent that we can promote competition in that sector and encourage the efficient delivery of high-quality healthcare goods and services, which is what you folks are all about, that's what we want to do. And in that sense, I think our goal is pretty consistent with yours. But within that group of 200 antitrust lawyers, they're divided up into about 8 different litigating shops. There is one group, the one that Marcus Meyer is in charge of now, and the one that I used to be in charge of about 10 years ago, the healthcare shop, which does nothing but focus on the healthcare sector. But they, in addition to looking at issues involving healthcare providers, they also devote a substantial amount of their efforts to the pharmaceutical sector, which is, of course, another area that all of us consume. And we've devoted a lot of resources in recent years to attempting to stamp out certain forms of conduct in that sector, including in particular pay-for-delay arrangements that slow the entry, from our perspective at least, slow the entry of generic pharmaceutical products and cost individual healthcare consumers and the federal government billions of dollars. We also have a group that focuses primarily on pharmaceutical mergers. That's been a hot topic. And we have a group that focuses in a different shop primarily, or to a large degree, on hospital mergers. And that is an area that was active about 15 or 20 years ago, then became somewhat dormant. When I say active, I mean from an enforcement perspective. It certainly hasn't been dormant from in the sense that there's been a trend toward consolidation. There absolutely has been. And there are local markets around the country where hospital mergers have posed competitive problems, and we've begun to challenge them again. Going back the last 5 years or so, we've had a string of successful challenges. We have 2 in litigation right now, actually, one involving Toledo, Ohio, and one involving hospitals in Albany. It's not Albany, it's Albany, Georgia, for those of you who may be from Georgia. I believe I'm pronouncing that correctly. But anyway, that's what the Bureau, that's how the Bureau's resources are deployed. We also, one of the myths that I want to address, at least it's a myth from my perspective, is that we don't provide sufficient guidance. Now, people can disagree about that, I suppose, but I'd like to think that I'm somewhat objective about this in the sense that, notwithstanding the fact that I've spent about 1/3 of my career either at the Justice Department or at the FTC, I've spent the other 2/3 of my career in the private sector, representing, in many instances, healthcare providers, and working with the enforcement agencies and interpreting their guidance. And there's been a drumbeat for years, particularly on the issue of clinical integration, that we need to be more specific, we need to provide more guidance, and there's been a resistance, of course, on the part of the agencies to issue anything that could be interpreted as sort of a cookie-cutter approach, because we don't want to dictate what forms clinical integration might take. There are certain building blocks that I think are now pretty well recognized and have been identified in the letters that we've issued that are certainly important, but that isn't necessarily the only way to do it. And it's certainly my perception that there are many, many, many examples of clinical integration in communities around this country where people who have read the guidance that we have issued and have understood it have moved forward and have been confident that what they were doing wasn't going to be challenged. So that's one myth that at least from my perspective, I think ought to be set aside. Another myth that may give you some comfort, I suppose, is that we put people in jail. We don't do that. We don't have the authority to do that. And we don't try to do that. And candidly, in the instances when we do challenge collaborations by healthcare providers that in our view violate the antitrust laws, they don't tend to be very close to the line. Where there's evidence of integration, an effort to integrate, an effort to deliver care more efficiently, either through financial or clinical integration, those aren't the cases that we bring. The ones that we bring tend to be situations where there's essentially no integration. There is often clear evidence of collective refusals to deal, or collective efforts to do nothing more than raise reimbursement rates without any offsetting benefits to consumers. And if you take a step back and remember that our clients are consumers who benefit from competition in all services, not just healthcare, in the absence of those benefits, we're going to be more concerned. But the cases we bring, if you look at them, are really not anywhere close to genuine integration or conduct that has the prospect of generating efficiencies. So again, that's myth number 2 from my perspective. Now let me drill down, start the drilling down a bit more. Although one other thing I want to preface, I actually, although Lee indicated I'm going to be here all day today, and I wish I could be, I unfortunately have to fly back to Washington this afternoon. If I had known that there was an opportunity to win an iPad, I might have changed my plans. And the other thing that might have caused me to change my plans was that one of the topics tomorrow is the way forward. And if we can get some clear guidance collectively as to the way forward, particularly with respect to ACOs, that would be welcome. I will say, you know, and a little spoiler alert here for those of you who are wondering how this talk is going to end. The bottom line on ACOs is very much stay tuned right now. It's very much a work in progress from my perspective, and I'll get to that in a little more detail. Okay, let me touch for a few minutes on clinical integration. As I indicated, antitrust standards distinguish between price fixing by healthcare providers, which is likely to increase costs and probably not do anything else, and effective clinical integration that has the potential to achieve cost savings, improve efficiency in the delivery of care, better manage utilization, and improve health outcomes. The former, where it's nothing more than garden variety price fixing or garden variety boycott of a particular health plan or group of health plans, those are the cases we bring. The ones that are more in the direction of clinical or financial integration, we are fans of. We want clinical integration to succeed because it really does offer the prospect of better outcomes and reduced costs, right? And that's obviously in the interest of consumers. It can take many forms, of course, reflecting local needs and conditions, and that's one of the reasons that we've been reluctant to issue edicts that people think they have to follow in every circumstance. The healthcare policy statements, the antitrust statements of enforcement policy that were issued back in 1996 lay out broadly how bona fide clinical integration can, with the potential for significant cost savings and quality improvements, may be demonstrated, and acknowledge, as have the letters that we've issued since, that efficiencies can be achieved through agreements among competing providers, either to share financial risk or to clinically integrate. And if there is sufficient integration, and if that integration, and if there is ancillarity, which is really the nexus between the clinical activities and the joint price setting, then the activities of the collaboration, the clinically integrated organization, will be subject to the rule of reason under the antitrust laws. And the rule of reason means that rather than being approached the way price fixing is approached, where there's essentially no defense, if there's an agreement to raise prices and there's nothing else going on by way of integration, there's really nothing to talk about by way of a defense. That's been well established for 100 years in the antitrust laws. Under the rule of reason, there needs to be a showing of harm to competition in a properly defined market, and the defendant has the opportunity to explain why the conduct, in fact, is pro-competitive and that the benefits of the conduct actually outweigh any potential harm. The cases that we bring have all been brought in this area with respect to physician collaboration, for example. They've essentially all been per se conduct that can be put in the rule of reason rubric is much less likely to be challenged. That's why that's important. And that's what our approach to clinical integration has been. Now, the ancillarity point, which is sort of it's almost metaphysical. The idea is that the collaboration, that there's an appropriate relationship between the integration and the joint price setting, and that the joint price setting is reasonably necessary to achieve the benefits of the integration. Now, as a practical matter, and I will say this from the standpoint not only of a law enforcement official, but from somebody who has counseled clients, that can be a tough issue because you can sort of deconstruct any particular aspect of the program and ask yourself, well, do we really need to jointly price in order to accomplish this? And on some level, the answer may be no. But there are also examples of collaboration that are more likely to be achieved if the organization is able to present itself collectively to health plans. And we get additional comfort, frankly, when we're dealing with groups that don't have a large share of a market, or groups that are non-exclusive, which is to say the members of the groups that are proposing to integrate and jointly negotiate are able to participate in other groups or are able to contract individually. And as a theoretical matter, there's no possibility of exercising market power, which is the ability to raise price above competitive levels, if anybody who doesn't like the price that's being offered by the group can negotiate with the members of the group individually. So non-exclusivity is, an important safeguard. We also recognize, on the other hand, that there's some tension, frankly, between the safeguards posed by non-exclusivity on the one hand, and the potential benefits of exclusivity on the other hand, particularly when you're talking about benefits that are delivered through integration. It may well be the case that a more tightly integrated group that operates more exclusively is going to do a better job of delivering those benefits than one that is non-exclusive. We understand that, but in that situation, then it's important for there to be enough providers outside of the exclusive group so that they can form other groups and compete with the exclusive group. I mean, it's quite possible that if you had a market with 4 or 5 tightly knit, exclusive, clinically integrated networks, you might have a wonderfully competitive market. And without regard to the fact that they were each competing on an exclusive basis. So we understand that there's some tension there, and that's one of the things that we try to take into account. But in close calls, non-exclusivity is an important consideration. So in 2004, again focusing still on clinical integration, we issued a report with the Justice Department called Improving Healthcare, a Dose of Competition, which laid out a broad outline of the kinds of questions that the agencies are likely to ask when analyzing the competitive implications of proposed clinically integrated joint ventures. And that's, again, I think part of the reason that the suggestion that we have been insufficiently forthcoming with guidance is a bit of a myth. I mean, among the questions that we told people they should be prepared to answer and to explain to themselves and to us where appropriate are what specific activities will be undertaken, what ends are they designed to achieve, what infrastructure and investment is needed, what specific mechanisms will be put in place to make it work, how will the effectiveness of the program be evaluated, how are the individual incentives of the providers being changed and realigned, a very important consideration. And the idea is, of course, that clinically integrated organizations are going to coalesce around best practices and they're going to hold themselves accountable for complying with them. And where they don't, there should be consequences. What results can reasonably be expected and how can they be measured? Is joint pricing reasonably necessary to accomplish the program's clinical goals? That's the ancillarity point I just mentioned. And is it necessary to have exclusivity in order to accomplish the goals? That's the exclusivity point I just mentioned. People, I think, can understand those questions, and I think many people can answer them satisfactorily on their own, and they have. And that's the reason that you're seeing, I think, a number of examples of successful clinical integration going on without FTC oversight or without an advisory opinion. Okay, let me move from the broader topic of clinical integration to the more specific topic of ACOs. Here again, just to be very blunt, my view, and I guess I should have prefaced my remarks with the standard disclaimer that's sort of liberating, actually, that I'm speaking only for myself and not for the commission or any commissioner, but that's never been more true than it is with respect to ACOs, because, as I said, it's a work in progress. We at the FTC and the Justice Department, in real time, I mean, literally, I think more or less as I'm speaking today, there's a meeting going on, and Chris White, who back here, who you'll be, one of the breakout sessions we'll be hearing from later, has been very involved in this. She's in our New York office, but another very sophisticated, experienced healthcare antitrust lawyer has been very involved in this. But we are going through the comments that we received and trying to determine our path forward. That is very much a work in progress. But the promise of ACOs, it seems to me, is obviously desirable. They're premised on the hope that greater coordination and integration will lower costs and improve quality. Our concern is not with that goal, of course. To the extent that they are going to pose competitive issues, it's going to be, from our perspective, in the commercial market. We understand that ACOs that are formed to participate in the shared savings program under Medicare, will be getting paid by Medicare, and we indulge. I don't know whether I don't think it's a fiction. We indulge the hypothesis that CMS is in a position to protect itself in terms to prices. However, it's certainly assumed by everybody, including us, that ACOs that form to participate in the shared savings program will also want to use the same approach in commercial markets. And that's where, that's where our interest arises. We want to make sure that the ACOs that arise are operating competitively in the commercial markets where the competition obviously makes a difference. They can't be given a blank check for price fixing or for the accumulation of substantial market power. Otherwise, prices in commercial markets would likely rise and the quality of care might suffer. So that's our focus. And with that goal in mind, we and CMS and the HHS Inspector General's office hosted a public workshop last October, and some of the people who are here today, I think, Lee, you spoke both at that one and at the one that was held in May, didn't you? We wanted to obtain information from industry stakeholders who have an interest in or experience with the development and operation of clinically or financially integrated healthcare groups, because we understood that there was a very close nexus between integrated groups that were already up and running and the ACO objectives. And the chairman of the FTC, John Leibowitz, opened that October workshop with the following question: how can we design rules for ACOs that are flexible enough to allow the healthcare community to collaborate to improve quality and decrease costs, but not to fix prices or create market concentration? That's really the challenge. That's the goal, and that's what we hope to accomplish. Now, there's a lively debate going on also in real time about whether or not the proposed rule that was issued will in fact accomplish that goal, I suppose. But what it does, it provides criteria for provider collaborations. This is the rule that was issued in March. Jointly to manage and coordinate care, and if they meet quality requirements, to share in the savings. It emphasizes the importance of competition to benefit Medicare beneficiaries, and there can be non-price competition, certainly, that benefits Medicare beneficiaries. And it mandates pre-approval antitrust review for certain ACOs. On March 31st, the Justice Department, Antitrust Division, and the FTC, who share enforcement responsibilities throughout our economy and in the healthcare sector, issued the proposed statement of antitrust enforcement policy regarding ACOs. That statement was intended to provide further guidance to ACOs so they can determine how to proceed without running afoul of the antitrust laws. The statement recognizes, and I want to emphasize, that many ACOs will not raise competitive concerns, and we want the ones that do not raise competitive concerns to go forth and multiply and flourish and deliver the benefits that we all hope they can. And we attempted to set forth a streamlined analysis by which they would be assessed. The policy statement that was issued in March explicitly cited the previous guidance that we've issued on clinical integration, and provides that rule of reason treatment will be accorded to an ACO if, in the commercial market, the ACO uses the same governance and leadership structure and the same clinical and administrative processes as it uses to qualify and participate in the shared savings program. So in effect, an ACO that qualifies to participate in the shared savings program is deemed to be clinically integrated. That's a big hurdle. It's deemed to be clinically integrated in the commercial markets. And that's also another important consideration. They are deemed to be clinically integrated and to receive rule of reason treatment without a separate analysis of the ancillarity issue that I talked about earlier, which can be sometimes a very challenging issue. In effect, for ACOs that meet the criteria of the proposed rules, ancillarity is presumed, even in the commercial markets. So here are some of the I hesitate to use the word highlights, given how they've been received. Here are some of the features of the proposed statement, which was the subject and has been the subject of a lot of comments, and which is, as I said, under further discussion in real time. Newly formed collaborations among otherwise independent providers formed after March 23, 2010, which was the date of the passage of the Affordable Care Act, and participate in the shared savings program. It's anticipated that they may also operate in commercial markets, indeed that most probably will. It does not apply to merger transactions. Mergers will continue to be evaluated by the agencies, as we have for years under the horizontal merger guidelines and applicable case law. So the safety zone and some of the presumptions that are afforded under the policy statement for newly formed collaborations explicitly does not apply to full-fledged mergers. We use PSAs, primary service areas, as a screen for market power. We understand that there's not necessarily a precise correlation between a provider's geographic market and its primary service area. That is intended to be a screening device. The higher the PSA share, the greater the risk that the ACO may have anti-competitive effects. Keep in mind that the way this process will work is that we plan to review each of these applications within 90 days. And that may make it difficult to do the sort of full-blown analysis that has led up to the, I'll go beyond that. It would make it almost impossible to do the full-blown analysis that has led up to the advisory opinions that we've given in the past, for example, or which leads up to our enforcement actions. I mean, we don't typically open investigations and get within 90 days to a decision about whether or not we're going to bring a case. But because of the desire to get ACOs up and running during this 3-year period that they are provided for under the Affordable Care Act, we are committed to a 90-day process. We do note explicitly in the proposed statement that the PSA does not necessarily constitute a relevant antitrust geographic market, but we believe it is a useful tool for evaluating potential competitive effects. There's some details about how the PSA is determined which I'm going to skip. They're in the rule. But there is then an important safety zone. If the ACO's PSA share is less than 30%, there's a safety zone. And that means initial antitrust review is not necessary by us. And the ACO participants' combined share must not exceed 30% for any common service in any participant's primary service area. Most providers within an ACO that falls within the 30% safety zone can be exclusive, but hospitals and ambulatory surgical centers must be non-exclusive regardless of the PSA share. And the rule provides that that this applies for the duration of the CMS agreement absent significant changes in provider composition. So that's an important, we hope, positive feature, a safety zone at the 30% level. There's also a rural exception that can expand the safety zone. It still applies if an ACO exceeds 30% PSA share due to the inclusion of limited number of physicians per specialty from rural counties or rural hospitals. Those providers must be non-exclusive, and the rural terminology is as defined by the Census Bureau, and rural hospitals are sole community hospitals or critical access hospitals. There are also some limitations involving participation by what we call dominant providers. And an ACO participant must be non-exclusive if its PSA share is greater than 50%, and no other ACO participant provides that service to patients in that PSA. The ACO cannot require commercial health plans to contract exclusively with it or restrict health plans from doing business with other providers. And the proposal that was issued in March requires mandatory ACO review by the antitrust agencies when the PSA share is greater than 50% for any common service that 2 or more independent participants provide. The effect of that is that the ACO must apply for and review and receive for review if it's above the 50% level, and receive a green light from the reviewing agency before CMS will approve the ACO for the shared savings program. We will, and this is important, we will consider information suggesting that PSA shares do not reflect likely market power and or substantial pro-competitive justification. So it's entirely possible that even a 50% share for some, or greater share for some service will not lead to the ACO's application being rejected. There may well be legitimate explanations for that that don't threaten competition. And we will provide a written response within 90 days of receiving the required documents. An ACO outside of the safety zone, that is the 30% level, but under the 50%, above 30%, but under the 50% PSA share level, may seek an optional expedited review. But if it does so and then gets a negative review, it can't participate as an ACO. So there's a middle tier where it isn't necessary to seek review, but it's available. We also lay out a list of particular practices that ACOs in that middle tier might want to avoid to increase the chances of concern if they do, either with or without seeking approval. One is they should avoid certain exclusionary conduct identified in the proposed statement, prohibiting tiered products, selective contracting, tying, exclusive contracting for non-primary care physicians. Exclusive contracting for primary care physicians is permitted. Restricting the health plan sharing of cost, quality, efficiency, or other performance measures, or sharing competitively sensitive information. That's always going to be a concern. If we have the sense that a non-exclusive or exclusive, but particularly this would come up in a non-exclusive joint venture, if the members of that joint venture were participating in other ACOs and were sharing competitively sensitive information so as to facilitate the coordination of prices among what should be competing ACOs, that would obviously be a problem. Okay, so on May 9th, we held a follow-up workshop. This was after the March proposed policy statement had been issued. We sought additional input from a variety of stakeholders, and public comments were submitted about a month, well, a little less than a month ago. I think the original deadline was May 31. It may have extended by a week. And just the antitrust agencies, I'm now separating ourselves from the comments that were directed to CMS, received 127 comments. We are in the process of digesting those comments. I suspect that some of them may have been authored by or on behalf of people in this room. And we deeply appreciate the very substantial and thoughtful comments that we received. I should note that we received them from virtually every perspective: providers, payers, consumer groups. In some ways, that's comforting in the sense that no matter what we do, someone will be happy. But it's equally true that no matter what we do, someone will be unhappy. That's life. One thing I've learned, I hope many years ago, but I'm reminded of it probably on a daily basis in my current job as Director of the Bureau of Competition, is that if I'm making everybody happy all the time, I'm probably not doing my job very well. But that's not our goal. It's just a fact. The comments are all over the place. They are, some of them will be impossible to reconcile. And they go to virtually every issue: the type of data that needs to be submitted, the focus on the formation date, the safety zone, the thresholds for the safety zone, whether we have the legal authority to deny participation in the shared savings program on this basis, whether the review should be mandatory as opposed to voluntary. I mean, typically, when parties seek an assessment in advance of proposed conduct, that's what our advisory opinion process or the Justice Department business review process is about, and that's always been voluntary. In this context, if you're above a certain level, it's mandatory. So that's those are among, that's just a small subset really of the issues that people have commented on, and I think as of, again, sometime today, we've completed our review of the comments. We're beginning to discuss them internally and with our colleagues, the Justice Department. And when I said stay tuned on ACOs, I meant it, because it is certainly possible, probably even likely, that there will be significant revisions to what was proposed. I mean, and here I really am speaking for myself, but if you assume that this is a desirable goal, and if you further assume that the initial proposed approach is likely to discourage people from pursuing it, then that suggests that there may be some modifications may be appropriate. But one of the things that frankly, we have no sense of, and it's an interesting challenge in terms of our resources. We know what we've been reading, obviously, about how many folks may or may not avail themselves of ACO status or seek to avail themselves of ACO status. But when this process began, we really had no way of knowing, and still have no firm way of knowing, whether we're going to get 10 of these applications or 500. And that has, it's not your problem, it's my problem. That gap has major implications for our resources, which are not being augmented by Congress to take on this task. In fact, we nearly were shut down by Congress a few months ago during the budget negotiations. We'd gotten to the stage where we had, and we talk about a wasteful exercise. We had to devote a lot of significant time at a very high level of the agency planning for the shutdown, notifying people who were deemed non-essential what the drill was going to be. Very unfortunate. None of us who are in the public sector came there to go through that experience. That's the end of that little parenthetical. A word or two about pioneer ACOs, which are, I guess, being perceived as perhaps a more attractive alternative to the proposed regulation of non-pioneer ACOs. That, of course, is the program that I gather is going to be limited to 30 ACOs, and it's being run by the Center for CMMI, the Center for Medicare and Medicaid Innovation. There is not the same sort of formal regulatory relationship between us and CMS with Pioneer ACOs, but it is absolutely the case that we will be discussing the role of competition analysis in their review of the applications for that process as well. How those discussions will unfold remains to be seen. All right, now that's the conclusion of the ACO portion. Now I guess I have a couple of minutes left, and I want to mention some legislative developments on the state level, which some of you may be aware of. They have definitely captured our attention. And that is that several states, there's been legislation introduced in several states to pass laws that provide broad antitrust immunity for a wide variety of healthcare provider collaborations. Connecticut is considering such legislation. New York passed something in its budget bill a month or two ago that no one, very few people who might have been concerned about it were even aware of it, I think, until after it passed. Texas has legislation under consideration, and we have submitted letters to both, we, the FTC staff, have submitted letters to both Texas and Connecticut, pointing out our concern about the approach that these legislative proposals are taking. We take this issue seriously because blanket antitrust exemptions, we believe, will deprive healthcare consumers of the benefits of competition. We recognize, and I hope if you've internalized nothing else that I've told you today, I hope you will remember this. We do recognize that collaboration may spur innovation that can lead to improved quality and cost savings. That's 95% of what I've been talking about today. And as I've indicated, the antitrust laws, we believe, already allow pro-competitive forms of collaboration. Antitrust exemptions are not needed, therefore, to achieve cost savings or promote improved quality and access. And if unintegrated providers are granted full antitrust immunity to jointly negotiate reimbursement contracts, those actions are likely to eliminate price competition, raise costs, and decrease quality and access for patients. And remember, those are our clients. We're not focused on protecting the interests of health plans or protecting the interests of providers. We're focused on protecting the interest of consumers. And if you have a situation where there is essentially joint negotiations or other forms of collaboration involved without any integration and without any benefit to consumers, that concerns us. So we have, as I said, responded to requests from members of the legislature in Texas and Connecticut, and both states have not yet passed the legislation. New York did. And interesting, in the background, this is just I'll pretty much close with this because I found it somewhat remarkable. It's why we care about these issues. In Connecticut, there was testimony from at a hearing from the president of the State Medical Society, and this is a direct quote. This reflects, unfortunately, a misunderstanding of what the antitrust laws do and do not permit. This is a direct quote. Without cooperative agreements, it would be virtually impossible for in Connecticut for physicians to talk about cost, quality, and efficiency as they relate to ACO and medical care model design. Close quote. So that's being teed up as a justification for blanket antitrust immunity. That reflects a completely wrong, completely incorrect understanding of what the antitrust laws do and do not prohibit. I hope, if nothing else, I've made that clear today. I also, we're going to continue to monitor these legislative developments in these and other states. We are going to continue to work closely with our colleagues at the Justice Department and at CMS to try to foster the pro-consumer goal of ACOs and of collaboration without risking the potential harm that can come from collaboration that isn't accompanied by integration and consumer benefits. With that, I will stop. Thank you very much.